Hello everybody. Assalamu alaikum, Sistakar, Namaskar to all the listeners. This is attorney Shah Peerally for another Shah Peerally Law Show. Today we are August 23rd and yesterday was Eid, so Eid Mubarak to all everybody and all the Hajis, all those people who went to Mecca for the Hajj. I wish them, hope all their prayers are accepted. So happy Eid to all, even belated by one day. So today we're going to talk, of course, about a lot of things about immigration. And before I take the callers, I think we already have some callers, Michael, but just bear with me a little bit. I have to talk a little bit about a few things that have changed over the past few days on immigration. On Friday, August 17, and before I start, of course, I have to give the disclaimer. Anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. You can contact our law firm at 510-742-5887. And the number to the studio today, 510-657-1170. 510-657-1170. And of course we have Michael, and we're going to talk about one thing that happened on Friday, suddenly, a reversal, actually a clarification from the USCIS, which is going to affect a lot of people, while at least give some relief to a lot of students who are on STEM OPT. As you know, there was a change in the law in May, which got effective on August 9, that technically, quote unquote, people could not, people who are on STEM OPT students, they couldn't work for a third party. That means basically they couldn't work for a consulting company. However, August 17th, they changed their mind. Well, they didn't change their mind because there was a conflict. If you look at it on the ICE website and on the USCIS website, there was a conflict. So they end up by reconciling it and saying, yes, they will allow third-party jobs provided you meet the conditions, right? And the conditions were you have to show a bona fide employer-employee relationship, although there's no definition on the student, under CFR for the students about that, but the definition usually comes from H-1B, and one of the memos talk about that in 2010, the Unlawful Memo. And second, of course, you have to show the training plan, etc., etc. But that's at least a little bit relief for many people who are working. However, a lot of people acted upon that when they put that law and stopped working, and that created a lot of friction because they lost their job, etc. So this is kind of very, very unfair. It looks like they will issue something and then retract it, or just like the memo about putting people in deportation right away, the NTA notice to appear, and then they say, well, they have not really kind of adjusted their system to do that. So it's a lot of uncertainty that is going on. I've never seen that really in my career. But guess what? It's happening on everything right now in America. Things are changing really in personally, I think it's in a bad way. But of course, a lot of people will believe otherwise. So now I'm going to take one caller, Michael, and then we'll continue. I think we have one caller, right? Anuradha? Hello? Hello? Hi. Hi. Hello. Hello. I think I lost. Hello. Hi, Anuradha. Hello. I think she's still there, Michael. Hello.
Hello. Hi. Is this Shah?
Yes, sir. How are you?
I'm good. Hi. Good morning.
Morning. Good morning. Thank you for
question, Shah, about my I-140. Can you hear me?
Yes, I can hear you perfectly. Can you hear me?
Yeah, I can hear you.
Yes, go ahead.
Okay, so I have a question about my I-140, and it's been filed in premium processing, and I got an RFE about ability to pay.
Yes.
My employer did provided a letter from CFO, and my employer does have more than 100 employees, and he did provide a letter from the company CFO, but I still got the RFP saying that they are not required to accept that as in proof.
Yeah, that's true. Again, another of those now they're really kind of taking cockroaches out, kind of. Okay, the rule says basically you have to. Yeah, go ahead.
Yeah, so my question is, I've been employed with my employer like from last 2-3 years, much before then the firm was initiated. So, and they've been like paying me more than the prevailing wage determination thing. So, can my employer provide my pay slips and the W-2 as in against the ability to prove RFP, ability to pay RFP? Sorry.
Yes, let me take advantage of that question to you, the question completely. One of the main requirements, just to let the listeners know, of the I-140 is to prove the ability to pay. There are several ways to prove that. Number one of them is to prove that you're already being paid that or more than that. So your check stub is good enough to prove that. As long as you were paid at the time when the labor certification was filed, that salary was that much. Number two is showing net profit. Basically, like the company is making enough net profit to pay you that amount. Number three, combination of net profit and your salary. For example, let's say your prevailing wage is $140,000 approximately. Okay, let's say you're making only $100,000. They just have to show a net profit of $40,000. The third way to show that is also a combination of net current assets plus your salary. So if they don't have net profit, you can use net current assets and add it to your salary. That's it. And then, of course, for employers more than 100, a letter at the discretion of the USCIS, unfortunately, can be accepted. So in your case, I gave that whole picture for people to understand. In your case, if your payroll at the time of the filing is exceeding that or equal to that, it should be good enough to prove the ability to pay.
And since the company don't have all those other financial documents, like you said, the profit and loss and the audited document, all those things, so just providing the payslip and the W-2 should be sufficient for this RFP, is that right?
Could be, but right now they're acting weird, so if in case there's some kind of denial and anything, you should right away refile the case and explain it. But yes, if your check stub and the W-2 and the report, wage report from the employer can show that they paid you that amount, and you should be good. Okay? And also put your tax return, just in case, to prove that you actually made that. They are not fake W-2s or something. Okay? Okay?
Got it. Thanks.
Perfect. Good luck to you. And that was a very good question because a lot of people ask me that, but I never had a chance to cover the whole topic. But thank you.
Thank you.
So let me take the caller, Michael. Hi, Anuradha. This is Shah.
Hello. Good morning, Dr. Shah Peerally. This is Anuradha. And I have a question regarding an F1 visa.
Yes,
so currently, I'm into US on H4 visa and I have applied for a change of status like 2 weeks back. And I received my receipt notice stating that my case is being processed in Vermont Service Center. And I was just seeing the case processing time for Vermont Service Center for I-539. It is showing as like 12 to 16 months. And if I go ahead with that, I'll complete my studies in like 16 months. So I'm worried that I won't be eligible for CPT. And also I won't be eligible for OPT. So what I should do in that case?
Okay. This is another very good question we're getting today. Yeah, so you're moving from H4 to F1. Right now, F1 is taking around 12 months, sometimes even 14 months. So the solution in those cases, fortunately, the only solution is to take an I-20 of consular processing, go outside, get a stamp of I-20 of a F1 and come back. Because if you try to do change of status from here, there's no way to expedite it. And this is something that is not happening, unfortunately. But, of course, going outside, there are risks, right? So the risk is dependent on many factors. For example, the school you're going to, your ability to cover your expenses, etc., etc. So if you don't want to take the risk, then don't go outside. But the thing is that if you go outside to get your F1 stamp, the F1 doesn't get stamped, you can always come back on your H4. Usually they won't take away your H4. But there's no other solution except to take the I-20 consular processing, go outside, get the F1 stamp, and come back. That's the fastest way.
Okay. And like some of my friends suggested me if I change my home address, like I'm currently into California right now, if I change it to somewhere in Texas, will there be any change in the processing time?
Not really. Unless you live in Texas, if you do that, it's going to be fraud. So be very careful, because those are that people use, but they are not necessarily legal tricks. These are pretty much kind of tricking the system itself. And I will not recommend doing that as a lawyer, because unless you move to Texas, you can't do that. Having said that, even Texas and everything, they are taking minimum 8 to 9 months. So no matter what, as my experience right now, it's not going fast. And plus, the problem is that you have to maintain status during that time also.
Okay. And just to let you know, like my H4 visa, the stamping which I had was only till like June 2018. And I have an extension till 21, but I don't have a stamping right now. So if I leave the country, so what do you suggest? I should go for H4 first, then I should apply for F1, or how I should do?
I'll just go first for your F1, and then if it doesn't work, then you just go ahead and apply for your H4. Because if you go for H4, then go for H1. It's no purpose, right? Your H4 is not going to get denied because your F1, quote unquote, got denied unless there was some kind of fraud. But like I said, there's always a risk of denial on F1. Even the H4, but I don't think you'll have a problem to get your H4 stamp, because H4 is stronger than the F1. Plus, there's no issue of INA 214B and H4. So going straight for your F1, if it doesn't work, then you take your H4 and come back.
And Dr. Shah Peerally, what about...
Go ahead.
I forgot.
So go ahead and you can call us later, 510-742-5887. We can do a consultation. But and then we'll try our best. Michael, do we have anybody else? Good luck to you.
Yeah,
hello.
Thank you. Yeah, thank you.
You're welcome. So, ladies and gentlemen, sorry, it's the radio, so I cannot go too long on call, so bear with me a little bit. And if you have any questions, you can always call our office for consultation, 510-742-5887. And if you have a quick question right now, we can take them at 510-657-1170. 510-657-1170. So I was talking about this issue that they did with student visas in the beginning, and that's kind of really getting people. It's very unfair what is happening, but I guess it's happening for everybody, for immigrants right now. No matter what immigrant, even citizens, immigrants are getting trouble. So green card holders, you name it, everybody pretty much. So we need to work with the system, and at the same time fight when we have to fight. So bottom line, I would recommend, if you have a situation where you're in a third party, you're in a STEM OPT, you're in a third party, you're working at a third party, make sure that number one, there's an employer-employee relationship. That means there are not too many layers. At least there is what they define as employer-employee. There should be dominion and control. And also make sure that the training plan is well set and how you're being monitored. And that's another issue that people are getting when they say monitoring. And people are asking if monitoring can be done through electronics, has to be done physically, and that's still questionable. But so far, there's no real precise answer, but we are thinking you can do it by electronic means. Let me take another caller, Michael, and then we'll continue. Hello? Hi, Venkat. Hello?
Hey.
Yes, sir.
Good morning.
Good morning, sir.
Yeah, morning, sir. Yeah. I have a quick question. So I'm currently on H1B and my visa is valid until 2020 February. And I got an offer from another employer and they filed my H1B. So my question is, if I get the H1B approval from my second employer, so do I still have an option to choose which one to select after I get the second approval also? I mean, whether to proceed with the second one or proceed with one, first one?
Okay, you're talking about a transfer, right?
Yes.
Okay, so you have one transfer going on with one client. Let's say with client A, you have client B file and client C also. Employer B file and employee C also file, right?
No, sir. I'm on H1B and my visa is valid until February 2020. Okay. Now another employer filed my H1. Second employer.
Okay. What do you mean another employer? Is it a transfer?
No. I got an offer from another employer and they filed my H1.
Yeah, that's what I'm saying. They transfer, right? They filed a transfer.
Yes.
Okay.
So if I get my transfer approval, so my question is, do I have an option to choose the first one?
I got your question. Yes, definitely. It's called an election. You can stay with employer A or you can move to employer B.
Okay.
Doesn't matter. Okay. But provided you have not already moved to B and A has cancelled. If you are still with A and you don't want to move out, you can just ignore B and then continue with A.
Okay. Thank you so much.
Good luck to you. You're welcome. We're having very, very good questions today, ladies and gentlemen. I think I have another caller, right? Is it? Hello? Hello?
Hi, Shah Peerally. How are you, sir?
I'm doing well, Nigel. I'm doing well. How about yourself?
Yeah, nice talking to you.
Nice talking to you.
Actually, I got some questions. That's the reason I was calling you.
Go ahead.
But the voice is not hearing properly. So what is the reason, sir?
I don't know. It might be some technical issues or phone. We've been having that for a little bit. But go ahead. I'm hearing you properly. Can you hear me?
Okay. Actually, I'm in stayed a long time and I got last 2 years back, 1 year back, I got a work permit. Now, actually, I cannot go because I put a political asylum for India. So, is there any way I can go to other countries and come back?
If your asylum is approved and you have a re-entry permit, yes, you can. But if it is pending, technically no, you cannot travel. It all depends on your situation. If you have another visa, let's say for example you are on H1B, you can always travel on your H1B. But if you have moved to the EAD, the work permit, and you are not, your case is not finalized yet, still pending, you cannot really travel. But it all depends where
I want to ask you the question. Thank you. It was so nice of you. Thanks for supporting all Indians. We are very happy to hear your voice in radio. Thank you, sir.
Oh, thank you so much. Thank you, my friend.
It's so nice of you. Bye. Good day.
Good luck to you. Let me take another caller. Hello, is this Dean?
Hi, Shah.
How are you?
Yeah, I'm good, thanks. How are you? I just recently filed my N400 for naturalization. My question is, can I file N600 for my minor child now, or I have to wait until the N400 is approved?
I didn't hear you. You said you have an N400 file, your naturalization, and it's pending right now?
That's correct. Yeah, it's pending right now. I just filed a couple of weeks back. So can I file N600 for my minor child now, or they have to wait for the N400 to be approved?
When the N400 gets approved, automatically the child who is a minor will be included in that if he or she has a green card. So then you can file for the N600 to get the certificate. That's right now.
Oh, not right now. Okay. Okay, thank you. That's all I want to know.
Should be fine. Okay, good luck to you.
Okay, sir. Thank you. Bye.
You're welcome. I think we have another caller. This is Shah Peerally 11A. Is this Sushma?
Yeah. So it's regarding my nephew. He is in India and his green card has expired. It's already 5 years. So is there any option he can come and reapply for re-entry?
Yes, he can try what we call SB1. And SB1, he has to go to the U.S. Embassy and explain why he let the green card lapse and he didn't abandon it. It's honestly, I'd say it's a 50-50, but actually not even 50%. It's like 30% chance of getting it. Most of the people don't get it. You have to go to the U.S. Embassy and request for what we call SB1. And actually, you have to apply it online first.
Hello?
Yes, can you hear me? Can you hear me?
No, I cannot hear you.
Hello?
Yeah, I can hear you now.
Okay, sorry for that. Okay, so you go to the U.S. Embassy and you apply for something called SB1.
Mm-hmm.
Okay, but I'm going to be honest with you, most of the time it doesn't get approved. How did your nephew get his green card?
With the parents, my sister sponsored him.
Okay.
And parents?
Where are the parents? Where are the parents? Hello? Hello? I can't hear, I'm sorry.
Hello? Yes?
Hello, Yushma, can you hear me?
Yes.
Yes. So, where are the parents right now?
Parents are not alive.
Oh, okay. Yeah, unfortunately, I don't think we can do much except go to the U.S. Embassy, try the SB1 and explain why he didn't come back to the U.S. all those years. And then, how old is he?
He is now 29.
29. Yeah, that's the only way he can try. Do the SB1, and if it doesn't work, then give me a call at the office. We'll see if he has other options, okay? Okay?
Is there any reference from India immigration lawyer?
I'm sorry?
He has to apply in India. That's what you said, correct?
Yes. But you don't apply that. You apply it online. It's just a form. You go in the State Department, just Google SB1. And you will get the link. There's no need for a lawyer for that. Okay? But the Indian lawyer won't be able to apply for that. It has to be done from a U.S. Licensed lawyer. But you don't need a lawyer to do that. Just apply it and explain the situation. Okay?
So explain the reason why he cannot able to come.
Yeah, he has to have a very important reason he didn't come back. Okay?
SB1.
SB1. Like Sam Boy number 1. Okay?
Okay. Thank you.
Good luck to you. Let me take another. Okay. So we don't have more callers right now, Michael. So I'm going to discuss a little bit about all the issues now, and then we can take some more callers too. 510-657-1170, and the number to our office 510-742-5887. And we are talking, of course, about immigration law and. The thing I was talking about is that not change of mind, but returning back to allowing a STEM OPT student to continue working with third parties have come back with some conditions, but at least there's some hope. Now, a lot of people basically also have been worried about this NTA memo where notice to appear as soon as there's a denial, this is coming back. So that's another situation that has scared people. And then suddenly they came back and they say, hold on a second, we don't have really the system set yet. So until the system is set, we won't be doing that. But the fear is already created. It seems like there's a lot of fear being created. Well, again, I'm not an expert when it comes to what they do. But I know as an expert in immigration law, those things doesn't really make sense. But unfortunately, we are in very tough times now. Things are not like before, and don't expect things to be. Avoid one thing, taking shortcuts, because a lot of people they listen to forums or to their friends and they take shortcuts. Those shortcuts are very often illegal, quote unquote, because people have tried to devise things that just give them an ability. I'm sorry, my chair's acting up. So the ability to do things in a faster manner, but the truth is that many of those ways are not good ways. So you need to be very, very careful. So that's one thing I wanted to tell people. Right now, you've got to be careful at every level. Let me take one caller and I'll talk a little bit about visas at the port of entry. This is Shah Peerally, you're live on air. Hello. Hello.
Hi, Mr. Khan. Thanks for taking my call.
You're welcome. You're welcome. Can you hear me?
Current title. Yeah, I can hear you.
Perfect.
So my current title is Senior Technical Consultant, and I have filed my green card with company A. Now I'm getting a job opportunity as a development manager, as a full-time job. So what's the best title I can go with which when I file my green card again with them, I won't have problems to vote my name?
You don't have to worry about the title. As long as you meet the requirements of priority date, you can port it. You can have a completely different title from an EB3, and then later on you qualify as an EB2 different position. The priority date you can carry it forward no matter what, unless there's some kind of fraud or mistakes or something like that. So it doesn't matter which title you pick, priority date will come on this side.
No, thank you very much.
Good luck to you. Good luck. And anybody needs help, 510-742-5887. Our website, attorneyonair.com, attorneyonair.com. And please also subscribe to our YouTube channel, youtube.com/Shah Peerally Law. Yes, I think we have another caller, right? This is Shah. You have an ear.
Hello.
Hello. How are you, sir?
Yeah. I have a question, like for my son. He is not completed 21 years. He is still on dependent visa. So if the EAD is filed before turning 21, will he get the green card?
Usually, yes. Because then he benefits from what we call the Child Status Protection Act. If the adjustment of status has been filed, then it kind of locks the date. But it's a little bit tricky how they calculate that. But usually, yes. But, yeah, go ahead.
Okay. So, I mean, even if only EAD is filed and the EAD is not approved yet, and still he will get that, right?
Well, it's not the EAD that is filed, it's the adjustment of status. The EAD is just a product of the adjustment of status. So if the EAD comes from the adjustment of status, yes, it usually we will get it. But now with all the rules changing, we have to wait and see. But the Child Status Protection Act will protect him if the adjustment of status, what you call EAD, has been filed.
Okay, so it doesn't matter that how long it takes. Even if he has completed 21 years after that, he will get once it is filed.
He should cover him too. Having said that, if he gets married or something, it becomes a problem. So be careful.
No, if he doesn't get married, then yeah, in that
it should be okay. So far, all the people who have filed adjustment of status are being protected by the Child Status Protection Act, although the law has not been very, very clear. So we have to wait and see how the Trump administration is going to treat that. But until then, so far it has worked for most people. Okay?
Okay. So it doesn't matter. You need to file the green card at that time. It should be
okay. But again, like I said, with all the things changing, we need to be careful. Okay.
Okay. Thanks.
Good luck to you. Let me take another call. This is Shah Peerally. You're live in here.
Hey Shah, yes, I have a question for my friend. So he had a brain hemorrhage over the weekend, and he was hospitalized in the ICU. And he's on H1B as a contracting person, and his wife is on H4 EAD, and he's covered through his wife's insurance. So the fear we have is, what if he is not able to join the contracting portion? I mean, they say the recovery is going to take more than a few months. So just wanted to get your advice on how do we proceed in case he's not able to show up to his job and the contractor cancels his H1B.
Okay, sorry for your friend first. It's really sad, but there is a provision in the 20 CFR for H1B. It's called an absence, a justified absence, right? So there's another word for it. It's not coming to my mind, but it's under the 20 CFR. I have an article on this on my website. So as long as he can prove that he is not capable of working and he is disabled, his H1B should continue. But then the company, provided the company don't terminate him, because then it becomes a civil issue where you have to fight the company. Because if the company terminates him, they can terminate for any reason. And then at this point, then he loses the H1B. But he can always transfer. He has 60 days to transfer. But technically, if he is not working because he's sick, and in his case it's a genuine sickness, he should be okay. So, yes.
So, what should we tell the employer and how should we proceed? Is there something that we could do, like a short-term disability leave that we should apply, or?
I'm sorry.
Should we apply like a short-term disability leave with this employer, or how should we intimate his employer, and how do we make sure his H1B is protected that way, his wife's H4 is protected as well?
Well, there's no way to force an employer to keep you on the job. You can make a deal with them as a matter of courtesy. Of course, if he fires him based on that, he might have a case in civil court. But it has nothing to do really to protect the H1B, unfortunately, and there's no provision for that. But there are extraordinary circumstances if he gets terminated that you can use to revive the H1B with another company. But at this point, the only thing is hoping that the employer is not such a bad person that they will let him hang like that without anything given to him. So only thing is just negotiate with them and explain to them what is happening.
Okay. The last question I have is, if his H1 gets terminated, will his wife's H4 be terminated immediately? She's on H4 EAD.
Yes. Get terminated because. But then if he revives the H1, if he's able to under extraordinary circumstances, then the H4 can be revived and the EAD will follow. Okay?
I see. All right. Thank you so much, Shah.
Good luck to you. I think I have another. Hello, this is Shah Peerally.
Yeah. So I'm Sumit, and my question is that I am working for employer A, and my I-94 expired on July 7th, but we filed extension in June 28th, so 1 week before expiry. And I got a RFP, big one, so 13-page RFP, which is very huge. So, if I have to plan as a backup option, since my I-94 is expired, so my prime vendor B won't start the transfer now, although they always wanted to. So the thing is that the prime vendor B filed my H1 transfer in 2016, and I still have their I-94, which is valid till December 2018. But I never joined them. So in case my employer A, whose I-94 is expired, it gets denied, the extension gets denied, can I still use employer B's I-94 to transfer or extension or whatever we can say it for the employer B?
I got you. Yes, technically yes, but there might be a lot of questions down the road. How come you never joined B, etc., etc. But the law says if the employer B has not cancelled your I-94, you might be able to use it. But are you sure they didn't cancel it? Because most of them are cancel it when you're not joining.
I have never seen the cancellation email from USCIS. If I see the website, it still shows me a tweet.
But sometimes they don't update it.
Yeah.
Sometimes they don't update it. So I would recommend that you just go ahead and talk to the employer to make sure that they have not canceled
Yeah.
it. But if they have not canceled it, yes, you can go work for them. But honestly,
And then,
there might be issues. They might ask you a lot of questions why you didn't join. So you have to have a good explanation. Okay?
yeah, right. So basically, that I-94, we can at least have a backup that in case this one gets denied, I can use that I-94 and say, just extend my I-94. I mean, visa for 3 more years. Like, we can file extension on that basis.
You can file extension with company B, but if depending what the reason A was denied, you might get the same problem with B. So be careful, and I cannot really give you an exact answer at this point, but even though the law allows that, I'm not trying to look at the case. So be careful when you do it. Talk to your lawyer. Talk to the company lawyer. Make sure they have to cancel it.
Okay, so another thing is that if I get denied, what are the options if we take out employer B from the equation? So if A gets denied, I need to leave the country and then maybe employer B can refile. B can refile or A can
Yeah, both can refile.
Yeah,
So
and I have B1.
to leave as soon as possible.
Yeah, so I have a B1, B1, B2 from 2011, valid 3 to 721. So can I stay here and convert to B1, or I can go out and come back on
not
B1?
anymore.
Okay,
Well,
I can come
if you go to B, if B is valid, then you can move to B1. But that B1 that is on your passport has nothing to do with the B1 you can get. You will have to do a change of status to B1. But,
Or I can...
it's not the one on your passport that you can use. But it's not a good idea right now. The best is to leave the country, refile the H1B and then come back.
Yeah, and since my wife is on H1 with I-140 too, so or I can go for H4.
You can just move to H4, but right now it's kind of late to move to H4. You could have filed it before, but the best way is just to leave the country, get an H4 stamp, come back, and then file for your EAD.
So her H1 is basically till 31st March, current approval. Is there anything within 6 months, if more than 6 months, she should have H1 that I go for H4 stamping?
There is there's no rule on that. Only thing is just like they usually don't allow people in. So what I would recommend, if you get a denial, give me a call. I can do an assessment. Better.
At least if it is more than 6 months, her H1 is remaining. Like on 1st October, it will be just 6 months. So if I get stamped in September, which is 6+ months, there's still a better chance.
Yes.
Okay.
And that's the best way to do it. H4, and you can move back to H1 from the H4.
Yeah. Okay. Thank you.
So take care. Good luck to you. And Michael, I can take more callers now.
Thank you.
So for those, I know we have a lot of. So please call the office 510-652-425-887. 510-742-5887. Thank you so much for listening today. I really appreciate it. We got a lot of callers, and I have to just kind of recap quickly. We also help people just to let them know with debt settlement, which is basically a way to get out of debt without having to file bankruptcy. Especially a lot of people are leaving right now, going to Canada or waiting in India until they want to come back. And they have some credit card debts or some other debts, and they don't want to keep it on their head, so we can negotiate and reduce those debts and get you out of them. We're not protecting your credit here. All we are doing is cutting off the losses and move on with your life. So if you need help, call us 510-742-5887. For debt settlement, the blog is yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. And I wanted to recap today this big announcement on Friday where they pretty much reversed their own thing. USCIS saying now that STEM OPT students are eligible to work at a third party. That means IT consulting company will still be able to benefit from that. And also just to let people know, we are hearing a lot of people getting at the airport. So be very, very careful. I have a YouTube video on this, and I want you to subscribe to the channel. It's very important because whenever I have some message to pass, and until the next show next week, I won't be able to pass it. And I'm not really, you can check our website, but sometimes even the website, we don't really have the resources to update it kind of daily. But the YouTube, since I access it, I just quickly post something there. So please check it and let me know if you need any help. 510-7425-887, and the YouTube channel is youtube.com/Shah Peerally Law. youtube.com/Shah Peerally Law, like my name plus law, LAW. And also, I wanted to let you know that right now, if you're traveling, be very, very careful, because we are hearing many people coming back right now. A lot of people calling us and saying that at the airport, even they have an approved H-1B, they are being questioned sometimes, and even they have a stamp on their passport, they are being questioned, some of them, at the airport about their degree, especially if it is not related to their occupation. That's becoming another issue. And also people, we are seeing a lot of people getting really weird RFEs, and if no RFEs, are being questioned really heavily on things that are not usually, we don't see I have not seen a lot in my career. So to put it simple, there are more complications now than ease, but we can deal with them. And I wanted to congratulate the team for still getting a lot of cases approved, including L1As, EB1A, national interest waivers, and especially IDT. I wanted to thank you and Sharif for doing an excellent job. And we have also Lubna and Shabana in the office. I wanted to say thank you and Eid Mubarak again for all those. Yesterday was Eid, and we are going to, the show will be replaying at night on midnight on Friday night, so you can listen for all our late listeners. Thank you very much, ladies and gentlemen, and anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. 510-742-5887, attorneyonair.com, the website. Thank you, Michael, and I think Amit is there. Amit, are you there?
Hi, sir, how are you?
Hello. I'm